In the next 60 seconds, I'm going to explain to you the case of Byrne and Company versus Van Tienhoven. So if you're ready to get them brain cows milked, let's get to it. Picture this. It is October 1880 in the world of business correspondence, a time when letters travel slowly by ship between England and Cardiff and New York. Communication is not instant. It takes days, even weeks for words on paper to reach their destination. In this era, a simple delay in the mail could decide whether a contract existed or not. Here's our players. On one side, we have Byrne and Company, a New York business who are looking to buy some goods. And on the other side, we have Van Tienhoven, a Cardiff-based company who are looking to sell those goods. Now the facts surrounding this case are relatively straightforward. On the 1st of October, Van Tienhoven sent a letter to Byrne and Company offering to sell them some goods. 10 days later, before the letter even reached New York, Van Tienhoven sent another letter to Byrne and Company, revoking the offer made on the 1st. But here is the twist. Byrne and Company had already received the letter on the 1st of October, believing it to be a valid offer, and sent their acceptance on the 11th of October, 2 days before they received any notice of revocation. When the second letter finally arrived, Byrne and Company had already accepted the offer. Van Tienhoven argued that the revocation was effective as soon as it was posted, but Byrne and Company argued that it was not effective until it was received. The court was asked to decide which of these arguments was correct. Before we get into the judgment, let's break down the IRAC method to understand how the court might approach this case. The I in IRAC stands for issue, which is what the case is about. The R stands for rule, which is the legal principle applicable to the issue. The A stands for application, where we apply the rule to the specific facts of the case. And the C stands for conclusion, which is the decision on the issue. So what is the issue in this case? Well, the key issue is whether a revocation of an offer is effective once it is posted by the offeror, or only when it is actually communicated to the offeree. This case was decided in 1923, a time when the postal system was the main form of communication. This was not a case of a telephone call or an email where the communication was near instantaneous. This was a case where the revocation had to travel by ship across the Atlantic Ocean. So the mode of communication was slow and unreliable. What is the rule in contract law regarding revocation of offers? Well, the general rule is that revocation of an offer must be communicated to the offeree to be effective. This means that the offerer must take some positive action to bring the revocation to the attention of the offeree. Simply posting the revocation letter does not suffice. The rationale behind this rule is that until the offeree has actual notice of the revocation, the offeree is still bound by the terms of the original offer. To suggest otherwise would be to suggest that the offeree could be bound by secret actions of the offerer, which would lead to too much uncertainty in business dealings. Now let's move on to the application. In this case, Van Tienhoven posted the revocation letter on the 8th of October, but Byrne and Company had no knowledge of that revocation when they accepted the offer on the 11th of October. In fact, the revocation letter did not arrive in New York until after Byrne and Company had accepted the offer. According to the rule, Revocation must be communicated to the offeree to be effective. The mere posting of the revocation letter does not constitute communication. Therefore, since the offeree had not received the revocation at the time they accepted, the acceptance was valid. Finally, let's move on to the conclusion. Applying the rule to the facts of this case, the court held that the revocation was not effective until it was communicated to Byrne and Company, since acceptance had already taken place before communication. There was a valid contract between the two parties. So remember, in order for an offer to be revoked, there must be some positive action to communicate the revocation to the offeree. Simply posting a revocation letter does not suffice. That was a summary of Byrne and Company versus Van Tienhoven. If you found this breakdown helpful, make sure you subscribe, like and share with your fellow law students, and drop a comment with another case you want explained in the IRAC method, and I will cover it in the next video. I hope this helps you get an A in your class and an A on your bar.